Good evening and welcome. My name is Ryan Koopmans. I'm an attorney at Nyemaster Good here in Des Moines and the chair of the Appellate Practice Committee of the Iowa State Bar Association. The Supreme Court's arguments are always open to the public. They always have been and always are, but they are held while most of us are working, or for some of us, as I see in the crowd, are in school. So a few years ago, the Supreme Court decided that it would hold these evening sessions so that we could come and observe what they do firsthand. It's an excellent opportunity for the public. It's an excellent opportunity for, I see, some of the children in the audience. I'm going to give a brief synopsis of what, and a very brief synopsis of what the appellate courts do, what the Iowa Supreme Court does. Most of you have probably seen a trial, if not in person, at least on TV, so you have some idea of what that is. That is not what this is. This is what happens after the trial. After someone loses, they feel that the district court, the trial court, got it wrong, they appeal to the Iowa Supreme Court. The difference between a trial court and an appellate court is that there are no witnesses, there is no evidence, and there is no jury. All of that's already done. All this court is doing is reviewing what the district court did and deciding whether they got it right or whether they got it wrong, whether there was some kind of substantial error that prejudiced the party below, and whether the district court proceedings should be reversed or should be done over again. The appellate process essentially works in three stages. So the first thing that happens is the lawyers' parties file what's called briefs. They make their legal arguments, they put together the record that happened below, and they tell the Supreme Court why they got it wrong. Each side files a brief, and they are always labeled. For the losing party below, they are the blue brief, and for the winning party, they are the red brief, and then there is a reply brief. They also file an appendix, which is this big thing right here, and that's the trial court record that they're using below. The Iowa Supreme Court recently made a very significant change that doesn't seem significant, but they went to and are going to electronic filing. That's obviously saves paper, saves trees, but more importantly, saves costs to litigants. It affects people's lives. This appendix right here, because of the number of copies that you have to submit, costs $1,500. The Iowa Supreme Court, because it is now going all electronic, that will save litigants that complete cost, and that will be a very big deal. The Supreme Court, after it receives these briefs, reads the arguments, does their own legal research, has law clerks that help them out with that, and then they come here for oral argument. And that's what you're going to see tonight. And if you think of oral argument as a presentation of legal argument, you're thinking about it wrong. Essentially, it is going to be a conversation with the court. Do not be surprised if when Mr. Thompson gets up, he's interrupted within the first minute to minute and a half by a justice and is going to be asked a question. And this is not going to be in the order. He may want to talk about one thing, they may want to talk about another. This is not the opportunity for the lawyers to present whatever case they want. It is the opportunity for the justices to explore questions that they have about the case, because they're very up on the case right now. You will see the justices actually reviewing, they have tablets, iPads. That's what these briefs go on. That's what the electronic filing is. So if they're looking at their pads, it's not because they're reading the news or they're looking at Twitter. It's because they are reading the briefs. After the arguments are over tonight, the justices will conference. They will talk about the case. They will talk about their positions. And then the opinion will be assigned to one justice. One justice will go back to his chambers. He will write an opinion, and he will circulate it to the rest of the court. They will then debate whether changes need to be made, whether some people disagree or agree. And once a majority is reached, the court will issue its decision. And if one justice or more disagrees with that, they will write a dissenting opinion. We will see that opinion in this case, most likely sometime, it could be in the next couple months, or it could be sometime before the end of July. The Iowa Supreme Court, relatively speaking, with the rest of the nation, is a fast court at getting opinions out. They do a very good job and have streamlined the process. That's a very big deal for litigants who oftentimes just want to know the right answer. Their lives are being held up while this case is in limbo, and the Iowa Supreme Court does that very well. Tonight, after the argument, you have a rare opportunity to come downstairs and talk with the justices at a reception. I encourage you all to do that and would love to talk to many of you there. So please enjoy the argument. It is not necessarily a spectator sport. You won't follow everything all of the time. but it is a very good opportunity, and I'm glad that you're here to witness it. So thank you, enjoy. Please be respectful. Please do not respond to the arguments. Sometimes, if you see a justice laughing, it's okay to laugh. A little levity is all right. But please be respectful, and please, again, turn off all your cell phones. Thank you.